Family immigration is a great option for many people. Many of us have family members that have previously immigrated to the United States and were able to get lawful permanent residency, a green card, or eventually citizenship. Some of us end up finding love and getting married to a U.S. citizen or lawful permanent resident. So when we talk about family immigration, we really are talking about spousal petitions based on marriage. We're talking about a parent filing a petition on behalf of children. We're talking about children over 21 years of age, young adults filing on behalf of their parents. So we're looking at this kind of triangle, which is essentially parents, children, and spouses. Those three categories are called immediate relatives. And if they're U.S. citizens, they have the highest preference within the hierarchy of immigration in the United States. Clearly, if a U.S. citizen is going to marry a foreign national, or if a U.S. citizen is a child, or if a U.S. citizen is a parent of a foreign-born child, they can do many things and they should be able to sponsor them and get preference. So that's essentially the gist of family type of immigration. There are other categories such as aunts and uncles, people petitioning for their brothers, other more distant relatives. Those are available in certain occasions depending on the degree of family relation and where you are in your age or whether you're married or not married. However, those categories have what we call low preference. So more likely than not, there's going to be a significant wait time for you to be able to get to your quota, because every country has assigned quotas on number of visas available per year. For example, Mexico, Guatemala, Honduras, some of the Central American border or close countries to the United States have such high significant amount of immigration and so many petitions that often these countries have to endure multiple years of wait time for certain categories. Good news is that immediate relatives, which is the spouse, parent, child, those relationships have a preference and go ahead of the other categories. In order for you to be able to obtain a lawful permanent residency through a family immigration, you have to have a family member that qualifies. Again, a U.S. citizen would be able to sponsor you. If you're the father or mother, you can sponsor your children. If you are, if you are a spouse, you can, get married and sponsor your spouse. It's very common. Again, the child can sponsor once they turn 21. They can sponsor their parents, both of them, on the basis of their status. What depends is the wait times, depending on whether you are a U.S. citizen at the time of sponsoring or whether you are a lawful permanent resident. Now, I suggest if you are a lawful permanent resident and you want to sponsor a family member, it's always very advantageous if you try to become a U.S. citizen yourself. So a great step would be to evaluate if you can become a naturalized citizen, get your passport, and then file the petition on behalf of your relative, because you will definitely have a preference over a lawful permanent green card applying for a green card. And that's what we recommend that you do. The main thing of family sponsorships, let's talk about marriage first, because it's a very common petition. If you want to marry somebody that's not a U.S. citizen, there are various ways to go about it. You can bring them on a fiancé visa, which means it's a K visa. You would then apply with USCIS for the K visa. Once it's approved, they would send it to the consulate where your fiancé resides in the country, the U.S. consulate. At that point, the U.S. consulate will process the visa, the K visa, for that fiancé to enter the United States with the intention of marrying you. That's the purpose of the fiancé visa. Then that fiancé, upon entering, will have 90 days, and only 90 days, to get married to you. If for whatever reason you break up or that marriage can't be finalized in 90 days, they must depart the United States. And caution, many people get into the trap of coming in on a fiancé visa, engaged to Joe, and they marry Thomas. And that's a problem. And I know it sounds funny and all that, but it's not. They consider that, the government considers that quite an infraction. So if you enter to marry Joe, you have to marry Joe or marry whoever your fiancé is on the application within 90 days. At that point, you can proceed with the rest of the process and get your petition for your spouse while they're in the United States. They can actually do it here. That's one way of doing it. Another way of doing it is the person can get married abroad. You can marry somebody in another country. They'll recognize the marriage. You don't have to get married in the United States. They can get married in another country. The US government would require legal proof of that marriage. So many common law marriages that are not necessarily recognized by the country, or perhaps there's no way to prove it legally, that may be a problem for you. You need to talk to a lawyer about that. But most countries will produce some kind of certificate of marriage. At that point, you can marry the person wherever you are. You, as the U.S. citizen or lawful permanent resident, you can go ahead and file the petition in the USCIS within the United States with the immigration agency. Once approved, your spouse can process her green card at a consular appointment abroad where she lives or he lives, and then they can come in with that green card. That's one way of doing it. Another way of doing it is if your spouse happens to be in the United States on some status, whatever that is, tourist visa, student visa, employment visa, whatever, at that point you decide to get married. You had a change of heart, you decide to get married, you can get married in the United States, and then you can file the petition with your spouse here. It doesn't matter if your spouse's stay expires during the pendency of the petition, the marriage petition. They can still stay within the United States lawfully because they have a petition pending. It's a legitimate petition pending. So they can do that. At the same time, we can apply, in addition to the petition for marriage, we can apply for an employment authorization. We can apply for permission to travel abroad, which is called advanced parole during the pendency. And we can apply for there's an affidavit of support and other documentation, and the adjustment of status itself. So the way I want you to think about it is the U.S. citizen, the sponsor, files a petition on behalf of their spouse or whoever, and then the beneficiary files an adjustment of status form, which is a 485, 2 steps. Now, if you do that within the United States, you come in somehow, you're here, and you get married, and you want to do the process while remaining in the United States, is perfectly fine. However, people need to understand that once we start that process, and until they get a travel authorization, they cannot leave the United States. They have to remain in country. Because if they do depart the United States without the travel authorization, they will stop the process. It's considered abandoned. And you have to start, no big deal, you just start all over again, but you just wasted time and money. So let's make sure that we understand that. We also have to understand the timetables, because right now, unfortunately, the government is taking a little bit longer to process these petitions. So you could be in country, what we call landlocked in country, for a period of 4 to 6 months, potentially. If you can do that, no problem, it can process. If you cannot, and you are the kind of person that needs to go back home to work or do something, then we need to process you outside of the United States, which is called consular processing. One or the other, it doesn't take longer. At the moment, they're taking about the same time. Yes, in order for you to be admitted as a green card resident of the United States, you have to be admissible to the United States. There are many, many, many grounds of inadmissibility. Some of them are, for example, health-related grounds. Some of them are unlawful presence, you were undocumented. Some of them are entry without inspection, you came across the river, across an unchecked border, you did not present yourself for check. So those things would make you inadmissible. Some things that make you inadmissible are things like crimes that you've committed, criminal history. Not all criminal history, but there are some crimes that we call crimes of moral turpitude. It's a big word, don't worry about it, I worry about it. But essentially, it's crimes that are felonies or severe crimes, drug-related crimes, murder, assault, you get my drift. So those are the things that you should be talking to somebody beyond your criminal defense attorney. You should be talking to an immigration attorney as well and coordinating. But some criminal behavior or criminal history it's okay. It doesn't get to the level of making you inadmissible. However, you need to talk about it. You need to make sure your attorneys know about it so we can present the case. So that's one of the reasons for inadmissibility. However, the big one that everybody's talking about that you need to know about is the public charge grounds of inadmissibility, which, by the way, went into effect February 24th of 2020. That's about a couple of days before I'm filming this video. And it's all over the news and it's very confusing. Essentially, what is happening is there's always a requirement that the person be able to earn a living. The government requires you do not become a public charge to the rest of us, right? When you become a green card. In the past, they require sponsorship affidavit from your sponsor. And to be honest, the standards were a little low, but that's great. You know, we want to make sure we welcome people. However, under the new administration, current administration in the government, they decided to make that a lot harder. So now they're looking at whether you intend or will become, or you're likely to become a public charge, which who knows, right? So it's now become a real issue. It's become something we all need to discuss at the beginning of a case. If you have used any public benefits, certain list of public benefits that we can discuss later, when you call us for more consultation, if you have used some of these public benefits while you were in the United States, that may disqualify you from getting a green card. There are ways to deal with that. You can wait a little bit more time, get off of these benefits, etc. What I want just to educate all is that it's something we need to be discussing because, again, it's a new rule. It literally has been a week in existence and we're all reacting to it. Nothing to be afraid of, it's just something to deal with. So what happens is your underlying petition, the petition for marriage, the petition for family, whatever, that could be approved and that's great based on what happened, the biological relationship, birth certificate, the marriage certificate, that's all great. But when you get to your appointment for your adjustment of status, whether it's at the consular level or whether it's at USCIS, then they're gonna get into whether you are inadmissible to the United States. Forget your relative, you. And the public charge will hit you, perhaps your criminal history, you may have one, or something, some arrest that happened to you, DWI, you name it. So make sure that you're open and honest with your attorney so we can know what we're dealing with. The visa family immigration, really, it's one form. It's Form I-130. It's petition for alien relative. We all use the same form. Your U.S. citizen or lawful permanent resident will use that form to file. That's what we call the underlying petition, the basic petition. And that only proves that either you're my kid or you're my dad or you're my spouse, you know, it's just really their relationship. Then the other form is the 485, adjustment of status. That's you being admissible or not. That's your form. Then we have the other forms, the travel, the employment. So the whole package is about 7 or 8 forms that we have to complete on your behalf. And again, it depends whether you're gonna do the process within the United States or whether you're gonna do the process consular. Then it depends on which form we file. For people that are the subject of a sponsoring petition, like if you get married, for example, if you get married and you cannot adjust in the United States by law because you do not have status in the United States, you're not in a lawful status in the United States, you technically, what you had to do is you had to leave the United States, apply at a consular post abroad in your home country, and then at that point, the moment you left the United States, you would be dealing with a 3-year ban from reentry or a 10-year ban from reentry, depending on how long you were accruing unlawful presence. So if you were accruing unlawful presence between 6 months and 1 year, it was a 3-year ban. If you were accruing unlawful presence between more than 1 year, then it was a 10-year ban. So many people were hesitant, or rather not, they did not want to leave the United States because the moment they got on a plane, they're not coming back for 3 to 10 years, regardless of whether you got married to somebody or regardless of a family petition. You were just inadmissible. So around 2014, I believe, under the Obama administration, The law changed, and in the law, USCIS, the immigration agency, created a system called the provisional waiver in which people were allowed to get a pardon or say I'm sorry petition about their unlawful presence. And they were able to file a form 601A and get a waiver of their inadmissibility based on unlawful presence. Now, that waiver does not apply to criminal behavior and public charge and any other basis for admissibility. That's a whole different discussion. We're just only talking about unlawful presence, okay? People that enter mostly without inspection. And so the provisional waiver, what we need to prove is that there will be a substantial hardship on the U.S. citizen that's sponsoring you, either your spouse, your parent, your child. If you were to be not allowed to come in, you were banned from entry for 3 or 10 years. If you can prove that, then it would be approved. You still have to depart the United States to get your green card, but then you go with your provisional waiver, and that inadmissibility doesn't apply anymore. So that's the process. The substantial hardship is kind of a high, difficult legal standard to prove. Essentially, we want to show that if you were to be separated from the particular U.S. citizen that's sponsoring you, whether it's your husband or children or parents, that they will suffer hardship, either economic hardship, emotional hardship. There are different ways. Medical hardship, for example. We utilize many tools to get substantial hardship proven, or attempt to prove it. We use things like psychologists, social workers, counselors. We do many, just trying to demonstrate that you are a good character, references, if you're a member of the community, chambers of commerce. You know, what we try to prove is what is our community losing and what is his family losing if you are deported or are you not allowed to come in if you were to go outside to try to get your green card. So it's very difficult it's not cookie cutter, it's very difficult to come up with a formula. All I can say is that we would work on a case-by-case basis. That after you get your green card status, essentially you can have it for 10 years and then renew it again until eternity, pretty much. I don't recommend you do that. A green card can be revoked. People don't understand that a green card can be taken away and revoked. It's difficult. It's not like anybody's going to come knocking on your door and take it away, at least not at the moment. But if you engage, if you get arrested, if you get involved in some situation, a negative situation, potentially you could be revoked. If you don't maintain it in good standing, meaning you depart the United States and you're out in your home country, Mexico, and wherever you're from for a long time, you may not meet the residency requirements and then you're gone. It's gone. If you don't pay your taxes, then you're gone. So it's still a sort of a status that is not for sure, right? It's a great status, but it's not for sure. So I suggest that for people that are qualified to move to the naturalization stage, whether it's 3 years for marriage people or 5 years for other people, that they move forward and get the naturalization done, because that is foolproof. Once you become a U.S. citizen, they can't take that away from you, pretty much. You could have anything happen to you in your life, but the citizenship, unless you turn it in voluntarily, you have all the rights under the Constitution of the United States. You have a lot more protection. And then you can sponsor your family members a lot easier. Well, I mean, again, rights and obligations, like anything. I mean, but once you become a citizen, you're one of us. And you're the fabric of America. You know, you're guaranteed the protection of our country. And likewise, you have the obligations of citizens. A green card holder, like I mentioned, is great. We do want to get you there, but it only takes you so far. And again, I've seen people that unfortunately have lost their green card through actions they have taken or inactions. So I always encourage people to consider becoming citizens. It's not that difficult, and it's a wonderful experience.